The Sixth Circuit Court of Appeals in Cincinnati upheld anti-gay marriage laws in 4 states, in Kentucky, Ohio, Michigan, and Tennessee. And it's the first appeals court to rule that way after 4 other courts of appeals around the country had struck down similar bans in other states. A private conference today, but there's nothing about gay marriage that's happening here
today. No, I just was curious.
Yeah, no, they're here. Well, the court said that it was bound by actually a 42-year-old Supreme Court decision in a case called Baker v. Nelson, which was a one-sentence decision that said there's no federal issue for us to decide here. And it was a case from Minnesota in which a same-sex couple had challenged Minnesota law seeking to get married and was denied. And the Supreme Court dealt with that in one sentence, and that's essentially been the law since. Now, the other appeals courts that have dealt with this issue have said they don't feel bound by this decision anymore because so much has changed in the intervening years. And the decision yesterday seems to make it quite likely that now the Supreme Court will take up the case, because there is what is known as a circuit split, where the courts of appeals come to different decisions about the same basic question. That's a classic case for the Supreme Court to step in. The question of timing is whether all the papers can be filed in time for the court to hear and decide the case in its current term, which ends usually in late June, or whether that would have to wait until the next term, in which case we would be looking at a decision that would come probably not before June of 2016, which of course is also in the midst of the presidential campaign.
Is everyone ready? Larry?
Yep.
Everyone ready? Yes, ma'am, we're ready. Go ahead, please.
Last month, in a sort of a surprise, terse order, the court turned away appeals from 5 states that were seeking to uphold their same-sex marriage bans. After that happened, Justice Ginsburg told an audience that there was really no urgency for the court to step in because at that time there was no division among the courts of appeals. And what she didn't say, but which was a part of the equation, is that the Supreme Court's denial of those appeals essentially made same-sex marriage legal in those states.